the first hour today. And then we'll move on to our safety leadership class in this, momentarily with another presenter, Harold Hall, Harold Hall. I've been with TAC for about 4 years. Prior to that, I was a county HR director in East Texas. And then prior to being in county government, I was the book world AT&T and in HR department. So just a little bit about me. Ever attended a TAC training before, this is considered subject matter expertise advice. And if you are in need of legal advice, please seek out that competent attorney for your specific situation. So some of the things that we're going to talk about today in the harassment discrimination is your employee protections under the law, so you understand what laws protect employees. We'll talk about different types of harassment. We'll take a few videos, and then we will understand what to do if we face a claim of harassment or discrimination. So what is harassment? We like to start with this definition because it's what the Department of Labor uses if you are to ever get some type of charge with the EEOC, the Equal Employment Opportunity Commission. So it's unlawful offensive conduct based on a protected class that alters the condition of an offensive employment. So if we were to break that definition down, unlawful, it's all about consent. You don't want it happening to us. Offensive, that's kind of a loaded term these days, because anything and everything can be offensive to someone, somebody, or somehow. It has to be based on a protected class, which is what we will talk about in our law portion in just a moment. Then it has to alter the condition of victim's employment. If you are just an employee on the call today and you are not a supervisor, you're probably thinking, how could I alter someone's condition of employment? I'd like to fire some of my coworkers, but unfortunately don't have the authority, right? So how you would alter that would be if the individual stops coming to work or asks to leave early or go home altogether or come in late, and they're historically a good employee, but because of the harassment and discrimination they're getting in the office because of an employee, a coworker, that kind of alters the condition of their employment because in return, their supervisor could discipline them for their actions of not coming to work. So that's how we would alter it. Supervisors in the room, elected officials on the Zoom, anybody who's on here, how you would alter that is unwillingly or unknowingly you terminated someone because of attendance issues or discipline someone with attendance issues that are related to a harassment discrimination claim. So why does all of this matter? Why is it important to provide these types of trainings? Our recommendation is that harassment and discrimination is presented to the counties at least every 2 years. I was in Health County 2 weeks ago and I saw all 405 employees of 410 employees doing this exact training. It's important that employees understand their rights and know how to face harassment or discrimination when it comes to reporting it to the county. So it's just best practice to my knowledge. No one has been harassed or discriminated against recently in Hill County. So I want to put that out there to you. I hope put someone to that's why HR girls here do this presentation, and that's not always the case. Basically just to protect your liability. So we'll move straight into the actual laws that protect you against harassment and discrimination. We're going to go a very high level view of what each law is. And I want you to remember to think about how that could associate with harassment and discrimination. So Title VII is civil rights up to 1964 begins those first protected classes that we have in that first definition. So it's your race, color, religion, sex, and national origin. And a lot of people don't know what national origin discrimination is. And it's one of the biggest claims that we have in our risk pool right now. Basically, we had a West Texas county that posted their tax office employees their workstation to print out a document that said only English can be spoken in this building. So if your little tape dispenser and enough documents to tape it around all four sides of the county courthouse. And a First Amendment auditor just so happens to be there. Anybody know what a First Amendment auditor is? There's a few head shakes in the room. Or if you don't, it is someone that believes it is their right as a US citizen to come in and audit county government buildings. And so they just so happen to be there. They posted a picture on social media to a couple of videos of that statement being up there. And now that county is being sued by its constituents and its employees that English is their language. So that is what national origin discrimination is like. And then of course, we've also seen an uptick in the sex discrimination as well. And that all leads to the Equal Work for Equal Rights Act, the Lilly Ledbetter Act is what we're seeing that, the uptick in sex. Age discrimination in employment act, does anybody know at which the government thinks you're old and needs age discrimination protection in the workplace? They're out of number.
Yeah.
A little bit older than that. No, the answer is 40. This gentleman goes the closest. The answer is 40. Age protection begins at the age of 40. So that means it starts in the hiring process and follows you through the rest of your career as a working employee in the US. A lot of you can see the internal checkbox going off, like, yes, another protected class I can add to my protected class list. I have a story about a coworker. We were on a call one time. We do a lot of virtual meetings because we all have office spaces down in Austin. And so we do a lot of virtual meetings. And we were on the call and my coworker, he called me grandma. That's a nickname in relation to age, right? Well, my boss was very quick to notate that I don't follow that character yet. But when I, being HR, not thinking, repeated back and said, easy there, grandma, he did follow that age protection. He said, ooh, I got you. So although how silly that would be true as age discrimination. Another thing that we've seen through the risk level is a claim about asking the simple question of when are you going to retire? That could be considered age discrimination. So I learned this from my assistant county attorney. I was the HR director. I was the nominal HR director, and it was a best. They did not have any HR policies. The policy manual was older than I was when I very first started there. And I was slowly trying to make the changes that needed to happen in order to protect the liability of the county. And this particular employee was the first assistant county attorney. He would come up to me and he would start every conversation with the same rhetoric. Good morning, Ms. Haley. You know, I'm 124 years old and I'll never be behind your HR tips. And I would just blow out the whole part of the conversation. And he would say that every single time. We still haven't been Wiggly in my town that I live. I don't live down in Boston, but we still have like Wiggly in Texas where I live. And I saw him the other day. He started that same conversation at the Wiggly. I'm 124 years old, and I was like, well, you know, Mr. Joe, you're probably about 135 at this point. So I haven't worked out in a long time. And he just laughed it off. But the learning lesson that I got from him was when I finally begged my commissioner's court to approve a position after 4 years of begging every budget cycle to give me an assistant in the HR department. That I couldn't handle 450 employees by myself. And so they approved it, I hired someone, and the county attorney, assistant county attorney Joe comes in and he says that same letter. And the employee, just trying to insert without into the conversation, asked him that simple question, Mr. Joe, when are you gonna retire? Well, he stamped his whole butt and said, young lady, that's age discrimination, I will not stand for it. And out the door he went. And she's looking at me, tears welling up in her eyes, and she's like, oh my God, please don't fire me, it's only me too. And like, okay, this is going to be a learning, teaching moment. I promise when Mr. Joe gets back to his desk, he'll call and tell you all about the teaching moment. Well, Mr. Joe had a nickname, my county had nicknames, so don't recommend it, but my county had nicknames for every employee basically. And his nickname was the Clap. Not because he was a ray of sunshine, but because he was always seen floating around the courthouse and never at his desk. So about 2 hours later, when he got up one floor above us to sit back down, he calls her and he gives her this whole spiel about how that could be construed as age discrimination. And I will never forget that. Because when I joined TAC, we looked some claims throughout the entire state, and sure enough, someone filed a claim and won the claim for age discrimination because of that simple question. So be mindful of that. The next law that we talk about is the Americans with Disabilities Amendments Act. This act begins at the hiring process. I have an employee who a commissioner who reached out to me recently and said, hey, I have this applicant that is asking for an accommodation in the hiring process. Is that something I have to do? And I said, well, I want to phrase this as you don't have to, but you can't require or accommodate every accommodation. We have to show that we are attempting to accommodate the accommodation. Because under this law, it states that an employer does not have to accommodate every disability if it doesn't fit the budgetary constraints or put an undue hardship on a county business as a whole. It is important that we document and look at each single one of these on its own merit. And so what this particular applicant was asking is that they were deaf and they needed a translator for American Sign Language in the interview process. And before he could think about it, when that request came through, he immediately said, I'm so sorry, we're no longer moving forward with your application. Well, what is that? Perception of discrimination against disability. We should have worded it a little bit different due to budgetary constraints, all different things, right? We could have worded it. But it has to be reasonable and it has to be something that is certified by a medical provider. So that's why we talk about this through the interactive process. There has to be communication. County employees, we can't read their minds. We also don't get their disability through osmosis. So you have to be able to come to us and ask us at the county level, your supervisor or your HR, Rachel here in the county, for some assistance with the disability process. And I want to make sure everyone understands that any physical or mental need we can see it or it can be unseen, I think. So it's also important to add, you can't discriminate against someone just because they have asked for accommodation. Another key part of this law is that you are not required to alter, change, delete, or even remove or create a new position to accommodate someone's disability. I actually don't recommend that you create a new position to accommodate a disability. The reason for that is when you create a new sidebar position for someone, it kind of muddies the waters in terms of what they are supposed to be doing. There is no new job description, so it makes disciplining the employee if they're not doing their job performance appropriately. It makes it really hard to discipline an employee because we just created a new job. And it's also important to notate this doesn't have to be long term. You can look at this every 30 days, every 60 days, every 90 days. That's a disability that is life altering, meaning that they are going to be in a wheelchair for the rest of their life possibility, then yes, that would be a long-term disability and we have to look at possibly accommodating that. But typically we like to say, we're gonna give accommodations for about 30 days and then reassess that. So we can't discriminate against that. Next laws, they're kind of one and the same, right? Because it's part of the Discrimination Act. You can't discriminate against a pregnant employee just because they are pregnant. That's an easy one. This law also states that you can't discriminate against them because they want to do the job that they were hired to do. It tells us that they can do that job for as long as they deem necessary. And the second part of this law, it's actually a standalone law, it's not the second part, but along the same lines, it's a standalone law. And basically, it's the Pregnant Workers Fairness Act. And this is the newest law that we talk about. This was created in 2023. Regulations, a whole whopping 12 pages, released in June 2024. And so we're kind of blindly stumbling through the regulations and making sure we're not violating these laws because there is no case law for us to back up to go, this is how it should be interpreted. So basically, it's an extension of the Americans with Disabilities Amendments Act in terms of it has accommodations for employees that are pregnant. However, under the Americans with Disabilities Amendments Act, pregnancy itself is not considered a disability. Just because you're pregnant, that is not a disability. Conditions arising out of pregnancy could be a disability. So for our pregnant employees who need accommodations for if they wear uniforms, they wear a uniform to work, and obviously their shirt is too small, their belly's from show at the bottom, their duty belt isn't fitting appropriately, whatever that might be, their pants don't fit them anymore. An accommodation under PWFA is to provide them a uniform, and we can't discriminate against them because they're in that uniform. They also go to give a few more examples of what accommodations would be in a experience act, and that can be that the person needs water or snacks available at their workstation, even if there is a county policy that states you cannot have water or snacks at your workstation, you have to allow an accommodation. Being able to practice slow living as an accommodation, allowing them more frequent bathroom breaks is also considered an accommodation here. And I think the biggest one that people don't realize is we're going to talk about FMLA in just a moment. And when we talk about FMLA, that is leave entitlement for an employee to take off work. Well, what happens to those pregnant employees if you don't qualify for that FMLA and they need time off to take care of themselves from ready for having? This is where Pregnant Workers Fairness Act kind of bridges that gap. To close that gap to allow pregnant workers time off, then if they are not eligible for FMLA. So that's used as a last resort, but if there be an accommodation request to use as which brings us to FMLA. I could talk about FMLA for hours. It's my favorite federal law in terms of employment to talk about. It's probably because that's what I started my career doing at AT&T. So I just love to talk about it. Because there is a stigma in county government that FMLA is bad, and if I get placed on FMLA, I'm going to get fired. And that's not the case. It's actually the complete opposite. FMLA is job protection. It protects your job and your medical benefits for a duration of 12 work weeks and 12 months. Also protects you from harassment or discrimination if you need to use FMLA for your own serious health condition, your spouse, child, or parents' serious health condition. If someone you're married to or yourself has recently had a baby, you need to take some child bonding. FMLA, that's okay. It also goes to say if there's an adoption or foster care place that you can take FMLA for that within the first year of the adoption or foster care placement. So FMLA is important historically under the law since 1993 when it was enacted. It is unpaid. The way it dictates if it's going to be paid or not is by your county policy. And typically in your county policy, it states you would use any comp time that is banked and then any sick vacation or banked holiday time in that order. Typically the way county policies are written. Like I said, job protection for a duration of 12 work weeks and 12 month year. That does not mean you get 12 work weeks of FMLA per occurrence. So per illness, as Dr. said, it is 12 work weeks that you have to share between any illness that you may have between yourself. There's also some military provisions under this one, military extendency leave and military care. So you can take some time off if you have military service members that are in need of that for rest and recuperation. Fair Labor Standards Act, it sets minimum wage. It also protects employees from harassment or discrimination in terms of if they were to file a complaint about the wages. Or if they were to participate in the Department of Labor investigation here at the county level. It protects them from that retaliation, harassment, discrimination. It also tells us how employees should be paid in terms of are they exempt employees or non-exempt employees. Do they get overtime or do they not? That's what exempt and non-exempt means. So non-exempt employees are usually eligible for overtime after 40 hours worked in a 7-day period. That is not the case for some law enforcement agencies. The Commissioner's Court entered into a 207 agreement under the FLSA, they would have done a proclamation in order to enter into the 207K. And typically, what we see there is law enforcement officers, detention officers, and the deputies do not get overtime pay until they have physically worked 14-day pay period, 86 hours in that 14 days. Some counties do have a 28-day cycle where they have to work 171 hours before they're eligible for overtime pay. You guys do choose a day do this, so and it's 86 hours. So just like to make sure what I'm speaking on, so it's not really that only one. So it also says that standards. It also sets standards along the lines of child labor. The question comes up from commissioners every summer. Can Jim Falk's grandson come work for the county barn and drive the tractor for me? Unfortunately, the answer is no. He cannot due to child labor laws around having machinery. If he's just digging ditches and digging dirt, absolutely you can hire him, but you cannot drive heavy machinery if they're under the age of 17. It also states that you're not required to offer vacation, sick, or holiday pay. And the only break that you are required under law to get is for nursing months. So technically under the law, 15-minute breaks in the morning and the afternoon, along with lunch breaks are not required. I recommend that. No, it would kill morale and everyone would be angry. But it is not required by federal law. Then the last federal law we will talk about today is the Genetic Information Non-Discrimination Act, also known as GINA. You're probably thinking, what does that even mean? How would I be discriminated against because I have a genetic disease in my bloodline? Well, the answer is you, the employee, or the supervisor, or whoever might overshare. And by you telling me, if I was your supervisor, that I need to have some time off to get my mother or father settled into memory care because they have Alzheimer's or dementia, I'm smart enough I can understand that's a genetic disease. And in return, if I were to retaliate against you by saying, right, take all the time you need, because if your mom has Alzheimer's, you might get it down number 2, and I don't want to deal with that later on. So just go meet with her. And you probably think that is an absolute outrageous reason as to why someone would be terminated. That was happening so frequently in the early 2000s that this law was created in 2008. So can't discriminate against someone just because they have a genetic disease in their bloodline. There's also a little piece of paper that goes with the FMLA paperwork that attaches to this little paragraph that asks the physicians not to share any genetic information in relation to that employee. Last one that we talked about is the Texas Workers' Compensation Act. This is a law in Texas that allows any employee to file for workers' comp, no matter how frivolous you may think the accident or injury is their right to file for workers' comp. Let them file for workers' comp. An employer should never tell an employee that it's not workers' comp, you cannot file for workers' comp with that. My best recommendation is to allow them to file it, do the first report of injury, be extremely detailed in the first report of injury to give the adjuster all the information that they need to provide an accurate statement or an accurate assessment over the injury to determine if it's compensable or not. Because under the Texas Workers' Compensation Act, if they are engaging in horseplay, it's not going to be compensable. So making sure and notating what they were doing on the first report of injury is imperative. We had a county not too long ago, maybe 1 month ago, where we had employees doing office chair races down the center of the courthouse. And you laughed, but one of them fell on and broke their arm. They immediately wanted to file workers' comp. The county let them file workers' comp because that's their right. But they clearly notated that it was considered horseplay and that was not a normal person's scope of their job. And the adjuster came back that the claim was not compensable. Therefore, it has not hit the county's office. Okay, but they still gave the employee their right. So it's all about making sure that you give the employees the rights that they have earned as employees of the United States and Texas. Another thing this law protects employees from harassment and discrimination Because you're not a hiring manager, or even if you're getting them from an interpersonal, you're just doing a transfer, a lateral transfer. You cannot call that previous supervisor and ask them, how do you put workers comp, and then use that to make your decision on to hire or take them into your office. Because that can be considered discrimination. So, you can't do that. All right. Moving on, we will talk about sexual harassment. And basically, it's unwelcome sexual conduct in the workplace. And basically, when I think about sexual harassment, my brain goes to, oh goodness, is male on female, female on male, someone has touched someone inappropriately, and now here we are, we have a sexual harassment claim. And that's not always the case any longer. It could be male on male or female on female, same sex. Or it could just be a conversation or the sharing of explicit pictures and videos. It's notorious that we have these TikTok groups in our offices and they share TikToks back and forth, but if someone takes offense to that and it's a sexual nature, it could be considered sexual harassment. I have an outlandish claim of sexual harassment, and truly, there's no way this is true, but it's my favorite example to use because it was true when it came from the county government about 2 years ago from a sheriff's office. So sorry, should have talked to the here in the mirror, don't mean to pick on you, this didn't happen. I know she was more than here, but this did happen, not here, well, preference, it did not happen here. But this county, they were at the JMI conference, the Jail Management Issues Conference down in Galveston. And they were having a grand old time in the hot tub. Throwing back a few beers, having a good time after the learning sessions were over. And they got this bright idea to have a tea party. You guys know what that is? Okay, if you don't, because I was naive and I did not know what it was either. But basically there was 4 gentlemen, 4 women, and then a co-worker that was not invited, a woman, an older woman that was not invited to come down to the hot tub with them. Well, the chief jail administrator got the bright idea to have this key party, and they took their hotel keys and they wrote their hotel numbers down on the keys, and all the girls put their keys in the hat. And the men drew a key. Now, whatever key they drew was the room they went home to for the night. Okay, inappropriate. Guess worse. They then documented the adventures on county cell phones, videos and pictures. How they got caught was the following morning. The chief jail administrator was leaving one of his direct report's bedrooms or hotel rooms, clearly doing the walk of shame. Like shoes in his hand, and the coworker was not invited the night before, saw him walk out of that room. So at this time, she pulled him aside and asked, what was going on? Is everything okay? Or, it was like, none of your business, move out. And wouldn't tell her anything. So when I got back to the county, she went to the sheriff, told the sheriff what she saw, and he started an internal investigation. Because under the Texas Constitution, if there is a claim of harassment, you have to investigate immediately. And that wording was changed about 2 legislative sessions ago where it said, used to say you have to investigate whenever practical, now it says you have to investigate immediately. And so he did his investigation, he called me, we talked over some few things. I even went as far as going down to see him, and we had some conversations on what should we do. Should we terminate everyone? Should we just terminate one? What's the consequences? Long story short, through investigations, we were able to determine that it wasn't just 2 of them, it was 8 of them. And we had hotel footage of them. We called the hotel, we got the footage from there. So we have each one of them going out of the rooms. And long story short, we terminated all 8. Well, they did, they terminated already. I was just starting the conversation. So harassment discrimination needs to be taken seriously at the county level. Like I said, it's required by law to be investigated immediately. For our ones that are attending our conference next week, I know we were talking about that this earlier before the session started. The County Risk Management Conference is going on next week, and they have 2 speakers about sexual harassment investigations. If you're not registered to go to the conference, that's okay. You can still register and do virtually here from the county. They are actually speakers from the Equal Employment Opportunity Commission. And so they are actually mediators that are gonna give you real life scenarios of how I mediate with AEOs. So all of that to say, sexual harassment is all about consent. So it leads us to our first video. None of this year is gonna work for using my computer for the Zoom.
Okay.
Sorry.
So we're gonna play it here, right? So we're gonna have feedback. Say again? Yeah, we're gonna
Yeah,
get feedback.
we're gonna get feedback.
Yeah.
But if you've never seen the consent video, it's kind of funny, it talks about consent and just because it's okay one day doesn't mean it's okay the next. So we talk about that sexual harassment. So, straight. Okay. One thing is we should talk about hostile work environment. So hostile work environment, kind of look different for lots of different people because that is subjective. It's conduct that is so severe or pervasive that it interferes with the individual's ability to do their job. I say it's subjective because there is no black and white, yes, that's hostile, or no, that's not, under the law. A lot of times people ask, well, hey, my supervisor yells at me all the time, is that a hostile work environment? It could be, depending on what is being said when they are yelling. If there is a scene, language being used, if there's derogatory comments being made in relation to a protected class, then yes, that could be considered a hostile work environment. I also like to say that if a reasonable person would perceive that as severe and pervasive, it probably is, okay? This next, we have a video here. It doesn't have sound anyway, so we'll see if it'll play. It's really hard to see, but the gentleman in the black is throwing things at the gentleman in the white. It's like pens, right? And he pulls the receiver down, the gentleman in the white, and says, please stop doing that, what I can imagine. And so is that homeless first one? Most likely, yeah, but this was the reaction. A little bit of hostile work environment at that point, yes, right? So we call that death by 1,000 paper cuts. Because someone is being pestered so much that it causes them to step outside their character, normal character. And whether they're being pestered here at work, or maybe they have a nagging wife at home that nagged them all morning to take the trash out, or they have some crazy road rage incident, here around the county, whatever it might be. I know you're not supposed to bring that stuff into work, but it happens, and we're all human. Don't have to be perfect all the time. And so we call that death by 1,000 paper cuts. So be mindful, someone that you need to stop doing what you're doing, you should stop. This one is important for this one here, so quickly look. Here it is. Okay, Rachel and Jay are coworkers, so in this little scenario here, it's important we do this specific one, otherwise one of my last slides did not make sense. So Rachel and Jay are coworkers who are in a consensual relationship. They're often seen showing physical affection in the workplace. Ryan works in the same office as Rachel and Jay, and their behavior makes them feel uncomfortable. Is this sexual harassment? Yes, it could be, right? But what if we were to throw a whole wrench in this scenario and say that Rachel and Jay broke up, and now Rachel is dating Ryan, but Jay has been promoted over Rachel and Ryan? What does that do? Doesn't this sound kind of traumatized, some possible harassment, some possible retaliation claims? So this is why we do this one, because that would allow As soon as they have you stay out of the trouble, and as soon as they consensual relationships, and people are like, lost it, every comes we have that, because they're fine until they're not. What I'd like to say about this scenario is don't get your honey where you get your money. There are other additions, right? I'm full of crazy little things like that. We're gonna skip those, another video. This video here is going to be examples of stray remarks and how they're used, throughout the workplace that could be considered harassment or discrimination. I think she says this report is retarded. And someone overhears her and doesn't like that language, or may have a son or daughter who's on the spectrum or whatever it might be. And they get offended by that. That could be harassment, that could be discrimination. I think at one point, there's a gentleman sitting on the corner of her desk, and she asked him to go get the paper off the printer that she was printed. And he says, what, are you really crippled or something? Why can't you do it? And then the camera pans over, and there's a gentleman in his wheelchair, the next vehicle over. Is that considered offensive? Absolutely, right? So just different things like that are normal rhetoric that we speak. We don't really speak, we just use those conversations out loud, could be considered offensive to some. So going back to our county policy, I want you to understand that your county does have a harassment policy. Then we need to make sure you understand the harassment policy. It provides your expectations, it defines your responsibilities, and it promotes compliance, and prevention. And it also tells you who to go to if your supervisor is the one that is harassing or discriminating against you. It tells you to go to either the county judge or your county attorney. Those are the typical standard ones that all counties use. Not sure what it is for specifically Bill County, but typically it's county judge or your county attorney. So early intervention, I'm always being an adult, right? Someone has a problem with you, goes to have the conversation and fix it. There's nothing wrong, or sorry, there's all kinds of things wrong. It's uncomfortable when you walk into an office and you cut the tension in the air of the night. Because Jim Wall and Sally Sue are feuding, and everyone else is walking on eggshells around the office to make sure they don't make you more than that. And so early intervention is just communicate the conversation, the issues, and focus on the actual facts of the information versus your emotions or feelings. Because when we come at our coworkers with an emotionally charged conversation, anybody, not just our coworkers, usually get nowhere, right? We're having those emotionally driven conversations. People tend to elevate their voices and yell at one another. Someone always ends up crying at the end, and it's like we resolved nothing, right? So going to that person, level-headed, trying not to make it personal, and just guiding the facts of the conversation. Hey, I didn't like it. We were in the team meeting this morning. You kind of threw me under the bus by saying X, Y, Z. Can you fix that for in the future? Can we come to an agreement that if something is wrong, the snide comments and remarks in the team meeting is not needed, you can come directly to me and we can come to a resolution. Okay. If you can't get that resolved with your coworker or your employee, consult with the HR or another manager or director or the sheriff or whoever it might be and try to get that resolved from there. This is just something I like to live by. You see something, say something. It's important because, like I said, some supervisors may not know something's going on, and if your word is able to tell them that something harassment or discrimination is happening in their office, then it might be beneficial to someone that is receiving that harassment or discrimination. They're just going to speak up. This is what your complaint process should look like. You should report it to management. Management then should investigate. And since we have to investigate, we want to make sure we're doing a thorough investigation and not a biased one. We need to know what parties involved. There is no such thing as off the record when it comes to harassment or discrimination. Then corrective action will be taken to stop illegal harassment, which may be discipline up to including termination. And then we have social that complainant, document it thoroughly in personnel records and get it over to whoever houses your personnel records in the county. And finally, what I like to talk about is retaliation. It's not allowed under the law to have good faith-based claims of harassment. So why do you think we have the words good faith? People make claims of harassment, discrimination against people all the time because they don't like them, and that's considered to be in bad faith. Or they may have recently been disciplined themselves and are trying to keep off of them and onto someone else. So that's why through our investigations, whether it's in-house or third party, we're able to determine if this was a good faith-based claim of harassment or if it was being bad. So your responsibility, go back, look at county policy, understand the rights and responsibilities that you have. Address this harassment immediately by doing your 3 Rs. Responding by asking the harassment to stop, reporting the times, places, and specifics, and then reporting it to management. Management will then respond and investigate. So how do you stay out of trouble? It's important to notate that what you put in your emails and your text message is final and public records. If it is county owned, it is subject to open records request, okay? So what you're putting in there has to be appropriate. So I can guarantee you, even though you deleted it, someone in IT can figure out how to get it off the cloud, whatever that means, I don't know. It's in my head, I don't pay attention to IT stuff, sure, there's social media on my computer. Or if you, not to say someone has a screenshot and send it to a million people in the county because you said something crazy, right? I used to tell my elected officials when I was the HR director in this county, if you were to type that email out before you press send, you're gonna reread it, right? You're gonna proofread, hopefully. And if you have the notion that my mom saw that, or if my grandmother saw that, or maybe even my pastor, would it change the viewpoint of what they thought they raised me to be? The answer is yes, that backside button should have use it, right? The pictures and posters that you're using to decorate your workspaces have to be word appropriate. There are some revisions that can't see others in the state of undress. So for instance, I learned this lesson, it was a very expensive lesson. My parents sent me over to Italy when I was 18. And I was young, I didn't know, I wanted to go to the Vatican. Well, I had tank top on, the spaghetti strap tank top, it was hot in Rome that day. And that's what I wore that day. Well, they were like, you can't come in, you have to cover your shoulders, the Vatican City. And it's like, okay. They're like, go up there, you can buy something, come right back, but you know, you have to cover your shoulders. So I did, went out, it's very expensive. Mistake, like I said, because they clearly saw the young American girl coming and took advantage of me. And I paid like $120 US for a cardigan to go into the Vatican. But it was a really cool experience. Another thing, when I very first contact was a county judge that I sat down with, one of my first meetings, and I will never divulge names, true names, I make up names, but I'll never tell you who they really are. And right above his head, to the right, there was a picture of him, not word appropriate, it was a solo picture, not like of him in his black, just, he was like 70 at the time. I was like, sir, not when you meet my meetings, but this is where I'm seeing liability. He immediately took it down after he talked. Practical jokes and horseplay, again, just be careful, because again, they're fine until they're not in the workplace. Fine until someone falls off the office chair and breaks their arm, the office chair exists. Again, here's some consensual relationships line where you are like, oh, she's lost her mind. So if you're honey where you get your money, it'll all be fine. There are laws that pertain to elected officials that can't, nepotism laws, but in terms of anyone who is not an elected official, having consensual relationships in the workplace is not illegal, just not best practice. The use of profanity, I have an aunt that touches her invisible girls every single time someone says a cuss word. And in relation, her son that she raised from birth, wasn't raised by anyone else, you see as long as a sentence and answer. And how she raised him, I don't know, but she takes great offense to those use of profanity. So try not to use it in the workplace. I know it's lip side every now and then, but people take offense to that. And if you're gonna give someone a nickname, make sure they're okay with that name. They could all relate back to protect the classes and get us in trouble for harassment and discrimination. So what I want you to take away from my part of the presentation is that employees must report incidents of harassment, the county must respond and investigate, and our whole goal here is to make sure you understand the rights and that we are eliminating unlawful and unwelcome behavior in the workplace. Do I have any questions? I am giving you about 15 minutes. That will take a quick intermission to get here the mic switched over to Carol and get this presentation up on the Zoom. But other than that, I don't have any questions online. Other than that, I appreciate you guys being here and we will start again right at 2 o'clock. Cool. Thank you.
She said it's a guy. He had a little bit of just paper, right, in that side.
That's what he said.
We'll call it.
Yeah, that's it.
Almost 10 years.